pretty eye. Goddamn. Damn, sooner or later, I'm gonna have a goddamn pretty eye me take though.
Damn, chick, you doing another song for pretty eye?
I can't deny her though. They my bestie. She's my bestie. That's my bestie. Your pair of eyes had me paralyzed. Toxic nigga, but you made me to a better guy. Smoke, but with you on forever, ever. I can watch you all day, girl, like you televised. You think like this nigga, they ain't never lied. I left the bitches alone, I had to pick a side. Look in your eyes, girl, you were hypnotized. Of course, it was your breasts, hips, and them damn thighs. Close my eyes, I'm still mesmerized. Trying to get mad at my bestie, I tried. That's my bestie, my pretty.
I heard she's the one, she's got it going on. That's my pretty eyes, baby. Yeah, yeah. She don't take no mess. My bestie is the best. That's my pretty eyes, baby. Yeah, yeah. I heard she's the one, she's got it going on. That's my pretty eyes, baby.
Hey, what's up? So it's Karen Reed Day. Motions hearing and motion to dismiss today. Plus tomorrow there's going to be a day full of that too there. So yeah, I'm a little bit behind, but we'll catch up. So yeah, I hope everybody has a blessed day, and let's get into this Karen Reed.
Shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. 22-117, Commonwealth versus Karen Reed. Can I please identify myself for the record?
Good morning, Your Honor. Laura McLaughlin. Good morning, Mr. Blufford. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan, Fourth Commonwealth.
Good morning, Your Honor. Al Jackson Street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Mr.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Your Honor. David Kennedy for Karen.
For that.
All right, so we've got a few things to cover today. We had a couple of questions to finish off about the defense position on the opposition to excluding the ARCA witnesses. Then we'll go on to defendant's motion to exclude.
Let me put on the
Crosby,
closed captions.
Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under DARPA grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion for.
Of course, for sanctions, but you won't sanction the Commonwealth, you assholes.
And in opposition to that, and a motion to reconsider.
Oh, there's closed captions. Let me change this. Hold on.
Tapes the Canton Police
Oh,
Station.
fun lady. Right there.
So that's the order that makes sense to me to finish up what we already had scheduled last week. If you don't have anything else. So the questions that I have. Before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Gannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Less is late to the game here.
Lady, what should it matter? They turned it over. This was supposed to be a whole brand new trial. They turned it over before the trial even started, but you have the Commonwealth just trickling. They didn't have it until after the first trial. So how were they supposed to give it up at the first trial? Yeah, maybe the emails. Okay, I can understand the emails. But as far as like the bill, like they didn't know about it until after the first trial. They were under the assumption that freaking the DOJ was paying for it all. I mean, lady, you really like to, you are very prosecutor friendly. You don't do anything when it comes to the Commonwealth and their trickling of evidence. But I digress. Whatever.
But you all know that when
And what's sad is this could happen to anybody. This type of stuff can happen to anybody. Man, bull crap.
one of you speaks, you speak for the entirety of the defense team. When one of you acts, you act for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Green?
I do, Your Honor.
Mr. Jackson,
Of course.
Ms. Little,
Yes.
and Mr. Leslie?
Yes, Your Honor.
So each attorney is legally accountable for the actions and statements of the entire team. So now the questions that I have, Mr. Leslie, that you said were welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you called. Could you stand, please, because I can't hear you.
Yes, I was going to go to the
Sure,
podium.
go ahead.
Thank you. I didn't want to stand when you were talking.
You could stand. All right, so the pause email is you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. You will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between Arthur and Mr. Jackson regarding comments.
Okay, lady, do you not understand? Like, they may have sent an email. Jackson may have not have read it. He may have read it. He may have just tossed it off to the side. They do have other cases and they do have other caseloads. Sometimes it is missed, but you want to always slap them on the hand, Miss Reed is the defendant and she's entitled to whatever counsel the freak she wants. Okay, this is a problem I have. If the Commonwealth had truth and facts behind their case, why do they have to try to discredit an attorney, try to discredit expert witnesses and don't want them on, all this extra stuff? If they had truth and facts behind their case, I see it so many times during trials. You always see the person that doesn't have truth and facts behind their case. They're scrambling like this. But he gets away with everything, huh?
Compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring or do you know that to be fact, that there was no conversation, emails, texts, letters.
So biased.
phone
I
calls.
can't.
Do you know that to be fact? Or is that what you are inferring, as you said?
I am inferring, Your Honor, I do not know that as a fact.
Okay.
Like, just give the same BS. I mean, the Commonwealth is doing it. Why not let, I mean, and then, you know, the defense, the Commonwealth does it more than the defense. And they're the one trying the case. They're actually supposed to turn everything over. You know, you want the defense to tie their hands behind their back, show them everything that they're going to impeach them on, show them everything this, show them everything that, and it's not fair to the defense. But whatever. I mean, this is just a bunch of crap. And
So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill,
which was before the February 18th deadline, lady.
itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time
Same time as what, Your Honor?
as the invoice?
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It did
Because they made it 2 days later, lady. Oh my God, here we go.
come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday.
So she's gonna sanction him. I hope that he doesn't get kicked off the case, and I hope she does the same thing for him, because this is a bunch of crap.
To clarify this, seems pretty clear. This was filed, I believe, on the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ARCA. The Commonwealth's motion to exclude these.
If she fucking excludes this expert, I swear to God, I would be appealing this decision real freaking quick, defense. I'm just saying that right now, because this is a bunch of crap.
Expert witness.
When she herself said that this was going to be a whole new trial. A whole new trial. That's why the Commonwealth ain't getting dinged for their late Sally Port videos and their chain of custody issues. And, we got to make up reports and all this other dumb stuff. She lets that fly by, when she should have dismissed this case a long time ago at the freaking leaf blowers and whatever you call it, red Solo cups. In all honesty, I don't know how anybody investigates a case like that doesn't get thrown off. Or, the text messages and stuff like that, all these cases riddled with holes. And seeing the TUI letters, I don't know how you look at the DOJ's letter that says, under good faith, they don't think they can allow this case to go forward. Because John O'Keefe wasn't hit by a car, and John O'Keefe didn't hit a car. So, yeah, lady.
Who were not hired or paid for by the defense is not made in good faith.
They didn't do the reconstruction. They didn't come up with a conclusion by the defense. They were not paid for that by the defense. What part do you not get, lady? Of course they got to be paid for their time. I mean, you had him come out there twice. Once for the voir dire, and then they had to come back later to testify. But you don't expect them to get paid? So that part they weren't lying about. The most important part they weren't lying about. I can't stand you, lady.
Faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the act of witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due.
Defense, start writing your appeal
How do you
now.
reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just wanted to make sure you were finished with your
Go ahead.
question. I learned that that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned,
You don't have
I'm
to
sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through. And when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ACCA is signed by you.
Your Honor, it is signed by me, but if I could, with regard to 3.3A1, 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing in something that critical of candor to the court. That's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
I really wish I.
All right, I'm not going to ask other counsel. All right, so let's move on to the next motion.
Your Honor, if I could, The tabs that I had, I've marked them as exhibits. I didn't do that last time. The weapon, and I had marked, Mr. Brennan has agreed to them going. May I just offer them in at this time? They're all marked. There are two. Your Honor's February 6th was exhibit 1. So I picked off on 2 and worked it out to 4. What would you like me to do with each, Your Honor?
You can hand them to the court officer, who'll hand them to
Well, there you are. Thank you. Thank you, Your Honor. And have you concluded what you?
yes, let's agree.
Okay.
Yes.
All right, so let's go on to your, did the Commonwealth want to add anything?
No, thank you, Your Honor.
All right, so
Good.
let's go on.
Son of a bitch and lying asshole.
499.
Part of my
So
privilege.
the motion of the defendant to exclude the testimony of the Commonwealth's witness.
Brennan, you need to stop treating this like it's a defense
Yeah,
case.
Brennan,
You need to get on the prosecutor's side there, bud, and do what a prosecutor does, not what a defense attorney does.
Reoriented
Take your
back to
time.
it. Thank you. May it please the court. The entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented. Your Honor
This is
well
the
knows
dog.
the inquiry under Dalbert Lanigan.
So this is I believe the dog aggression expert or whatever. He's really not a doctor. He's a veterinarian. So yeah, they're saying that he knows about dog bite or dog aggression and what happens and all this other stuff. But every dog is different. That's one thing. And certain types of dogs are different. I know German Shepherds. They unless they're not trained in such a, and they're very protective of their owners. Like they don't like new people around their owners. They truly are guard dogs. But this is the dog aggression expert. I guess they're going to talk about his mythology, because that's what Alessi likes to call it. And they're going to talk about that. And I believe we may get into a little bit of they found Chloe. So, all right. Just for those that haven't been following the case, that don't know much about Karen Reed. Karen Reed, this is a whole crap show in a handbag. The first trial ended in a mistrial, so they're trying her again. The evidence has been all wonky. She's accused of running down her boyfriend 22 miles an hour in the snow backwards and leaving him on the front porch or the front lawn of another cop's yard. No one saw him. No one seen her do it. But that's the conclusion they came up with. There is no evidence. The DOJ even got involved. And were investigating the case. They handed over 3,074 papers to the defense and the Commonwealth, saying that in good faith, they could not allow this trial to go forward. and because no one wanted to listen, or because John O'Keefe wasn't hit by a car and John O'Keefe didn't hit a car. So, yeah, they just ignored it and are still pushing forward. And now, oh my God, I didn't even realize that I was offline. That really pisses me off. Hey, StreamYard, stop kicking me out my own stream. Anywho, I just went down a whole little rant about Karen Reed. For those that don't know her, don't know about this case, she's already been tried and she got a mistrial. So they say we're going to run it back. But she is accused of running over her boyfriend in a quote unquote blizzard. But it was just barely starting to snow. 22 miles backwards. Yes, I said 22 miles backwards. Ran into him. Supposedly just hit his arm and it made him pirouette and fall in the snow. And the reason why they're saying this is because where he was found was on another cop's lawn. They're saying he didn't go in the house. Other cops didn't investigate the house, inside the house, to know whether or not he was in the house or not. And the FBI, DOJ got involved and said, in good faith, I can't allow you guys to try this case because John O'Keefe wasn't hit by a car and a car didn't hit John O'Keefe. So, yeah. So they still went forward. And her defense is she was framed that she thinks that there was a fight or something in the house and they left him there to die, not her. Anyways, I think there's a lot of reasonable doubt from the leaf blowers to the solo cups. They didn't treat this case like it was a fallen officer. They treated this like it was a homeless person that had no name, no face, no case. It's truly sad when we should all be treated the same because nobody's better than the next, in all honesty. But, in our society, you know, you have to have a higher ranking for some weird reason. But anyways, okay, back to Mr. Crosby.
Inquiry. Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do. And I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements. So it's very clear that's the subject matter of his testimony. Your Honor stated with regard to Dr. Rentschler that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Point. Only an MD can do that. That's what Your Honor said was the clear law in Massachusetts. Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian. He's not a forensic odontologist. And those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established by saying, well, you know, this case is not about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm. And yeah, you'd have to be a medical doctor to treat, but that's not what the issue is, so I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor. With regard to his area of expertise, it can't be more obvious than his own proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualifications prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further than the qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense that when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's no documentation of that. But let's assume hypothetically it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog. And this dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object. It just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ADFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in a relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study, he doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor, that the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That dooms completely their second prong of doubter. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used. They're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically the mold of dentition. And in the most recent submission, the Commonwealth put in very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept our arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists. And even then, the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking
I was talking this whole time and I was on mute. Okay, so this is pure speculation. However, I feel that the whole Daubert hearing with Dr. Russell was so they could come up with an outline, a strategic way that they could get their expert to say something about molding and checking the arms from, supposedly they found Chloe all of a sudden when she was nowhere to be found in the first trial when the defense asked for Now they found her all of a sudden, and they made a mold of her teeth and stuff like that. And I just feel like they're putting they're putting the Daubert hearing towards this guy, the guy that he's arguing to not allow, to come up with a report that counters that. So, anyways, all right, back to the thing.
Taking measurements in molds and comparing them to the womb. 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis.
Bingo!
The first, she says, is that he treated the arm of the decedent as if it is a static, plastic, mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in the defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine. But the fact is, her main point is he never accounted for that in his methodology. It's not an opinion. It's a methodology. So, and again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support. But he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people take those photographs, have to be trained, they have to give a fair and accurate depiction, and you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My. She had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin. Human skin, when there's any pressure, particularly with a bite, it moves, it dimples, it hits the muscles, etc., etc. He gave no account for the condition of human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is in the second paragraph, they said his master's thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read his, I read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about, on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate what he doesn't do in his thesis is even mention his own methodology that he used here. In 107,
Oops.
there is now one reference to the methodology he used in his two. I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, very, and I couldn't agree with Dr. Crosby more on that. He then talks about, in his thesis, about the fact that there's no accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says. Although the ABFO does not specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that you just, even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology. He never worked with a forensic odontologist. In the case law that we point out, even in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his
That's where they have the Daubert
PhD thesis, which is more recent,
so they
2023,
could come out, so they could,
maybe in that
you know,
thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities in Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods in reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior. Second sentence, page 63. Classifying dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentioned what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might think that's what it is. He's not. He was a police officer for 22 years. And even then, he didn't deal, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, aggressive, et cetera, et cetera. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm?
Good argument.
He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications to do that. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell in her ability to testify.
Yeah.
If it was a close, no, not if, since it was a close call, for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby. So
But she's not going to deny it because it's the Commonwealth.
For a Daubert hearing, it's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of Lucy.
What does a behaviorist have to do with bite marks? I don't understand that.
Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object. Is he? Are you planning on doing that?
I wouldn't ask him to do that, no.
Okay. All right, so I'm hearing
Yeah?
yes.
Mr. Alisi tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr. Russell never had before this case.
Where has he?
In preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. That was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Alisi's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive. Variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Alisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor. There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he hasn't, I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the exhibits that I have are attached to the Commonwealth's, the defendant's motion?
They
So
have-
I don't know that I have all the reports.
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. he did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the bite mold analysis report of Dr. Crosby, which is not in
I
this
have
package.
that, I think that's attached here, I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth, and then I asked him to supplement a report regarding the mold.
And that's been provided to the defense?
It has, but it's not been provided in this package, so I can provide that to the court. So I'll supplement those two different items for the court's reference. In addition to his experience, he was chief of animal care and protective services of the city of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate canine brain project, 2023 to current. It's associated with Harvard University. Duties include the investigation and documentation of dog bite and related human fatalities. Also, division management consultant for animal care and protective services, city of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now, in Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. So when we compare, I'll refrain from getting into too much of a comparison, when we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that he has measured the distance of all of those teeth specifically. And then in his methodology, he outlines each group of lesions, specifically lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look, as Mr. Lisi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case, he finds canine DNA. So he does look to alternative sources, and mindful, there was pig DNA found. So it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence that there is no animal DNA. And so while there are different methods, and some of the things that Attorney Lisi spoke about, dentition, deal with human biting, not dog biting, his methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case. He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based, not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered, and he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to comment on your case in chief?
Absolutely not.
All right, Mr. Alessi, any follow-up?
Thank you, Your Honor. Thank you.
The Commonwealth did not address in its presentation, you heard, one probative, legal, or factual point I made because they can't. Specifically, the Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what? It's important. You can be qualified to testify, and if it's what Dr. Crosby's behavior was, the dog an aggressive dog. I get it. But the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. Wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number two, Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now...
Hold on, so that's exhibit 1 and 4.
Yes, exactly.
Give me a minute. Just put it back again. All right, so what page?
Every page. The point is, there's not one footnote in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted. And nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
Okay.
So he's got it in alphabetical order. Importantly, the page before 1399 at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case. You can't have an expert report that does a data dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did. And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, But where does he tether his methodology to one of them? He doesn't because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is because he's participated in autopsies, he must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that that book is not peer reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth that the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Daubert, you gotta have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior? In Daubert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard, but what is it that he is participating in Harvard in? This was from the words of Mr. Brennan, canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on a reliable methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology. So I am still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion,
I'm gonna let him through
where
anyway.
is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified under Daubert-Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Anything else, Mr. Brennan?
Briefly.
I don't know why he gets to go twice.
On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinions.
Yes, you told us
I
that
will give
before,
you
dude.
specific cases where he's been qualified in state and federal court. Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Lisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's affidavit in support, this
Okay, hold on. How do you know Dr. Russell didn't write her own report? Just because she asked like how to put it, how to put her resume, doesn't mean she didn't write her own report, sir. See, you love these little jabs and hits and all that great stuff when you have no truth and facts behind your case. That's what's sad, dude.
something to be intellectually honest about it, striking, kind of like her original report where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter of somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
We'll show those court cases, mother fudger.
So before we move on to the next motion was, it was filed after the other motions that we've finished here. It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative of Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Leslie, this is you again, right?
It is, Your Honor.
All right, so I'll hear you. And this is paper 515.
May it please the court. Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground.
Nobody knows. You can't get hardness of the ground
with regard to his qualifications
on the ground, and
he is
right when
not,
it's found, it's only like 2 or 3 inches
on the hardness of the ground.
The ground doesn't start getting frozen until snow has been on the ground for a while, and it has been frozen for days. Frost doesn't count. It's about snow. I mean, we get frost on the ground and then it melts away. I mean, we're talking about snow that stays. Like if frost stayed all day, yes, we can probably argue that the ground was hard. But this is absolutely ridiculous. I mean, anything they can try to do to wiggle their way right through this case because they have no truth and facts behind it. So they got to pull up every little thing that they can, like the ground was hard and all this other dumb crap that they do. What about the facts? Just the strict facts. Prove to us, F the ground, prove to us that he was hit by that car. Prove to us.
He is not a geologist. He's not a pedologist, i.e. a soil scientist. There's a specific field for that.
What's up, Spider Rider? Don't you start. I don't need tomato on my face.
Scientific discipline that blends water movement.
It's too beautiful for all that. Just
kidding. Particularly in the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes. So his certified weather statement is hard as a rock. I believe I'm looking for it.
Hard as a rock. Since when can it be hard as a rock?
Exhibits attached to your affidavit, Mr. Leslie?
Get out of.
So one's exhibit 1. I don't see any.
I'm sorry, Your Honor. It's exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it. All right. I don't see anything that says certified weather statement. It's an email, right?
no, his report is exhibit, well, it does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that 1, he's qualified, and 2, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion,
They're trying to railroad
quotes.
Period.
And Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation,
And the ground is hard as rock.
Never heard it. Because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells
That'd be
one
funny if they
that
started
this is
doing
not
that.
the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor,
Oh,
he's
she's
not
gonna let him in
qualified in this
too.
area.
Just FYI, she's gonna let him in too.
He doesn't even state a methodology to come to the opinion, let alone show that
Gonna let him
if he
in
had a
too.
methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Dalbert is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor,
Just the simple
Mr.
fact
Gilman,
that he
the
doesn't look like
meteorologist,
he was
should
hit by a
never
car. I can
reach a
find him.
jury to
There's no
talk about hardness of the
or
ground.
guilty.
Thank you.
Mr. Brennan, first question, do you intend to call this witness in your case in chief or for rebuttal?
I do, case in chief.
Right, I'll hear you.
Thank you. The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed.
It only started
about
being a blizzard
the
on the 20,
temperatures,
20,
the
29th.
wind conditions, also the snowfall. It seems that the only complaint the defense has
It was found
is the
early.
ultimate opinion that
Early on in
ground
the
appeared to be
snowstorm there,
hard as
bud.
rock. I think that concern is easily remedied. I do not need to ask this
It's easier to
expert
find
if the
taillight
ground
pieces
appeared to
in
be as hard as a rock.
2 inches of
I
snow
can ask
rather than
him
freaking
about
a
the
foot and a half.
documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions. to
And
be
then
a
it looked
blizzard.
like it was just
Also, he can
magically
measure the
there
snowfall
on
that
top of the snow.
accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't
Yes,
need or would
over
not
a
ask
period of
Mr.
time.
Gilman to talk about the ground hard
It
as a
just
rock.
barely started
We
snowing,
have
dude.
a handful of first responders who will give lay opinions. with
You
common
can't
sense
tell.
that the
You
ground
can't
was hard as
say
a
that
rock.
it was hard as a
And
rock.
state police
It takes
who
freaking
excavated
more than a
testified that
day,
kind
I
of thing,
think,
so
with
Mr.
snow on the
Gilman does
ground.
not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
What's sad is that you guys are trying anything and everything because you don't have truth and facts behind your case. Trying a case should be about truth and facts, okay? Finding justice, Whether you win or lose, don't freaking matter. Get your egos out of the case and let the facts fall where they may. But you know that this investigation was crap. You know that's why you're backbiting and fucking chasing your tails and trying to discredit all these other witnesses that are actually freaking experts, because you don't have a case. I'm going to be trying to get somebody off the defense because if I have a case.
Would you say that, Mr. Lessons?
This is just crazy.
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic, because just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G. 2005, freeze thaw effects on penetrometer resistance in shear strength.
Why don't you put those in writing? Was that just a Google search? I saw that you had it on your.
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
No.
Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
I'd be pleased to provide a copy to the Commonwealth.
All right, so I'll take this under advisement. So how long do each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, or the cases and the qualifications of Dr. Crosby?
I can have that to you today.
Great, okay. And those articles, Mr. Leslie, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
Would you like me to hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Leslie? Do co-counsel have copies?
Oh, no, co-counsel doesn't have any of this, Your Honor.
Okay.
I just need to black out something here that's.
Sure. You don't have to do it right now. Do it before you leave.
I'll do it before I leave, Your
And
Honor.
that
Thank
way
you.
there, we'll see to it, Jim, can you get a copy made for everybody? All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions. And this involves a transcript that I've read. I've listened to the actual recording. Maybe it makes sense to take a 15-20-minute recess. Now, does that make sense to everyone? Okay.
All right, so we're
Is
agreed.
the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just the transcript? Actually, I'm gonna see counsel.
Take a seat. Quiet, please, still the record.
Oh, righty then. They're on break, or they got a sidebar going on and a break. Yeah, this is crazy. Okay, let me see. Let's see. Come on. Well, why is this not working?
To disseminate this information to the public.
Okay, short break. So I don't know why this isn't showing up. This is done. It's like not giving me the. It's not giving me the Zoom. Like I can't see none of it.
We're back in session, you may be seated.
Sure. All right, so, Mr. Brennan, I will hear you on this motion.
Thank you. As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there is no good faith basis whatsoever that that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information to the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We did turn it over as a text message, and notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3.6. They've alluded continually about matters that have no basis in fact. January 18th, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office.
Hey, Hood.
Implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on Court TV with Miss Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is,
Where was that Court TV again?
I can get the date for your honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also,
I want to know, okay, how do they know like people are calling with tips and all that other dumb stuff? You know, attorneys takes tips all the time and watch YouTubes all the time and stuff like that. You know that, right? I don't get what. Anyways,
The Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does.
what are they
No more
talking about?
Symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately. Behind the
Let them do what they want to do. This is a bunch of crap. Like, you're such a crybaby. But it's okay when you want to use the media for your attention, right? It's okay for the DA to fucking open his mouth, right? Man, get out of here. This is true.
Be putting out information, oftentimes inaccurate, to sell the story before the trial starts, so that we can have.
How do you know it's inaccurate, dude? How do you know it's inaccurate? It's not for you to decide. Quit defending this case. How about you do what you're supposed to do and put truth and facts behind your case rather than freaking, white knuckling it all the way through and throwing spaghetti everywhere you can find. That, throwing spaghetti is the defense's job, not your job. You're doing more defending of the people in the house than you are proving that she hit John O'Keefe with her car. Do you not realize that? Dude.
Trial on fact. There should be a gag order on all of these attorneys, every single one of them. And the Commonwealth will not speak either. Ms. Reed, I'm not asking for a gag order for. And so in light of the history of these repeated violations, in light of the inability.
What repeated violations? How about, let's talk about the Commonwealth's repeated violations. Let's talk about that. You always want to cry baby your way through stuff because things aren't going your way, because you know the case is trash. But you want to make a name for yourself somewhere down the line, or you're trying to make it up to Morrissey or whatever. Come on, dude. Come on. I wish the federal government would just, I know they can't step in on proceedings. They can only step in when she's get found guilty. But still, this is a bunch of crap. This is a bunch of crap.
For the defense to restrain themselves in light of their purposeful, intentional, and obvious efforts in order to best try to maintain a fair jury in this case is to impose those sanctions. And that's what I'm asking for. Thank you.
Mr. Nitty, you're arguing this yourself?
Yes, Your Honor. May we approach this?
Okay.
It shouldn't matter what they say. It shouldn't matter. Prove your case. That's what should matter. Okay? You have the media that has proven her guilty before she was guilty. You had that. When that meatball Morrissey got up there, and I'm only calling him meatball because, I've never heard of a DA making a public statement saying she's guilty when she should be always have the presumption of innocence. Anybody should. That's what a fair trial is. Let your facts fall where they may, and let a jury decide that. You want to sit there and cry, oh, inconsistency, inconsistency, wah, 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 wah. But everything they've stated, they have proof of. But you want to discredit everybody that they have on their side, huh? Even the federal government. It's crazy. I don't know why I didn't let this go through. Oh, this ain't gonna tell me shit. Anyways, this is dumb. Absolutely dumb. This is dumb. Dumb, dumb, dumb. God, all he does is cry baby. I have no facts, and I really want to win this case. Cry baby. Fucking cry baby. But you persecute her, man, the media, you let the media persecute her. Then you have that stupid meatball piece of shit fat mother fudger all up on there saying, oh, no, there was no detectives there on January 29th. Well, why wasn't there? When you have a dead police officer on another police officer's freaking lawn. The meatball part. He is a meatball. You should see this fat mother fudger. I'm fat, but this mother fudger is fatter than I am. Shoot. Okay, meatball head mother fudger. Anyways. He likes his meatballs, I guess. I don't know. It's just what everybody calls him. Because he's a loser, a lowlife. Never, ever, ever have I heard a DA say she's guilty. She's guilty. She is the only one responsible. Blah, 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 blah. Before it even goes to trial. So you're deeming her guilty, and you're supposed to be the one that's supposed to say that she is presumed innocent until proven guilty in the law. I mean, in the court of law. But you didn't do that. You wanted to hurry up and rally behind your detectives. They weren't there that time. Oh, yes, there was. There was one. Oh, you skipped right past that, didn't you? Oh, but the lead detectives weren't there, so you're all right. Because they were too busy in the Sally Port messing with their vehicle, huh? Mm-hmm. Why was there no pictures of her car before you even put it in the Sally Port? Why? I mean, everybody takes pictures before they even touch it to make sure that nothing is tampered with. But you don't even have that. You guys don't even have that. So you want to cry baby your way all the way through stuff. That's just crazy. Okay, do what you do. Crazy as hell.
Thank you, Your Honor. And thank you, Court. Your Honor, as I mentioned at sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply with the court's protective order. That's evidence that I did not intend to violate the protective order and that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate. And I recognize the court's discretion in this regard. With regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial. His opinions about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it's certainly not an instance.
Why are you trying? Okay, why are you trying to protect a public servant in the first place when their duty, their oath is to protect and serve? And if they aren't protecting and serving correctly, it should be out in the public because you're a public servant. You are hired to protect us, the civilian. You're nobody special. You shouldn't have special privileges. If anything, you should be held to a higher standard, especially if you are holding a badge. That's the problem. Is these cops get held say, oh yeah, they protect and serve, so they're a higher standard. No, they're human like the rest of us. And if they make mistakes, they damn sure should be in the freaking courtroom like any else would be. So you plaster our text messages all over the place. Why wouldn't you plaster freaking cops when he's held to a higher standard than us? He is supposedly better than us because he's held to that higher standard, which he's not. So just like everybody else, he should very well be public. Anything he puts out there, any text message he puts out there. Crybaby.
Where I, flagrantly revealed or even inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety, I would submit. At all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information coming to light in this motion that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order that this communication got by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
Do you want to address the disclosure of grand jury minutes?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
I did, and I do have concerns about my ongoing obligations, so perhaps I could have a moment sidebar.
Sure.
Of course. Can we do it on a sidebar? Because I don't want the public to know anything.
I mean, you only mute the sidebars when anyways. And when you don't want the jury to hear. I mean, that's the whole purpose of public hearings. Hello? What do you call it? A journalist, they could write a story and it could grow wildfire. I mean, like a wildfire. Shit. Look at Turtle Boy. Turtle Boy is the one that, opened the can of worms and got public involved in the first place. I don't know what your deal is. Then you shouldn't have any media in your in your court hearings. Then, if that's the case, because you want to crybaby your way through it. So sad. So sad. Should have nothing to do with what? Whatever. Should have nothing to do with it. Oh, Hurry up. I want to see. I don't know why this isn't working. Why is this not working? Hello? 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 Let me go on mute for just a second so I can see where the heck we're at. Hold on. Wow, I guess they're not. We're almost done. That's crazy. How long is this? Oh, Lord have mercy. We're still. These short breaks take forever. Doom, 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 doom. No, no, no. Oh, this ain't even playing. Hello. Hello, play. Come on, play.
Ladies and gentlemen of the jury.
No.
Haley Anthony.
No. Back. Thank you.
Reed and her attorneys have been well established and was well-known public knowledge as a result of the that were laid out by the Commonwealth. And
The only fan. Come on. Ooh, I think it's moving. I think we got action. I got an action satisfaction. Nope, it just moved to the left. Move to the left, to the left, to the left. Everything you own in a box to the left. Come on, man. Come on, man. Really? They really ended it?
is important here as well.
Hold on.
This is appropriate to make in public because there were.
Hold on. Okay. There we go.
All right, Mr. Unetti, go right ahead.
Thank you, Your Honor, and thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in.
We did that because that was material that needed to be done at site.
Oh, I understand, Judge. No. And I'm
Just
thinking,
want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that of, I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the first assistant U.S. attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement? And what was the date that you all found out about the what Mr. Brennan just announced?
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information?
So wait, but there was reports. I mean, it was all through the media that that sources had told people that the case was no longer ongoing, that it was closed. I remember this. It was like a week or 2 weeks ago. But you're trying to tell me that a letter came through and it says that the federal investigation is still ongoing? The defense didn't have nothing to do with that, but the Commonwealth wants to say that they did. Okay. Sure. Who are your sources, Kenny? I mean, I was going to call him Kennedy because, yeah. Daniels, who were your sources? Obviously, you should have vetted them.
When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. Just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
So who told the defense that it wasn't? I mean, who told the Commonwealth it wasn't ongoing? Let's hear you lie about this, fucking Brennan.
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
Since when? Since when?
I'd like the court to...
Since when? Since when? Tell us. Tell us, Brennan. Where in federal history have they ever told somebody that may be a target of a federal investigation, such as a police department, detectives, stuff like that? You know, even the DA may be a target. When have they ever said that their cases are closed unless it's publicly? They don't run to a news source and say, oh, yeah, no, they come out and say it.
Take a particular care But when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Court TV was not in the courtroom.
Oh, stop. Backbiting and nail biting, you know? I mean, shoot. Nail biting and backbiting.
Thank you. So what I'd like to do now, there are new motions that were really just filed. And what I'd like to do, I have one that has a response. So it's the motion to
Maybe you should stay organized there, Judge.
amend the scheduling order to give the defendant a little bit more time for their motion to dismiss and the Commonwealth's opposition. I would like to hear that now. We need to give them a minute. The parties have any problem with hearing that motion now? It is a
No, Your Honor, I think it's very brief.
motion. All right, so I need 1 minute, Mr. Jackson.
Of course.
Can you write it? You gotta go from the ones from this morning, the new ones. I have to check. All right, so you're both prepared to argue this motion, right? The motion and the opposition.
I'm so sorry. Your Honor.
So if both sides are prepared to argue this, the motion to amend the court scheduling order,
Yes.
and the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition and just informed defense counsel if they're looking for a date this week if the court's available.
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I, speak with counsel? May I address the court, Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G.I.A.M. Pietro, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of Sallyport videos, and then about another 15 actual videos. I basically...
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Has anyone on the defense team looked at them?
I know Ms. Little was...
Yeah, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court that I've gone through it in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves, dragging files that cut in and out. There's about,
Or maybe you should tell her.
don't quote me on the exact number, I believe approximately 9 videos from the
She
Sally
looks like
Port
she
garage
got a little
wall.
bump there.
I have not watched them in detail.
But have you noticed the quality? Is it something you can actually see, or is it blurred and?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the
So
table.
what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just wanted to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, or I assume it was Ms. Little's motion filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue.
I have not looked at them, Attorney Riley did, and he represented that they're all the videos we've already turned over, same quality as we previously provided. They're just copies of the same videos, although they do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting that, we passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do. I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sally Court video and related evidence. That has to be filed by Thursday with the idea that we will have a hearing on this on Friday. We have Friday already blocked off. This way here, you can all leave for today. And we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Miss Giannetti after 5:30 one night. So we need things filed by that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Commonwealth's response, any idea?
Of argument time, Laura?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Of course, yes, I believe we will, for sure.
How does that schedule work?
It works for the Commonwealth.
I need to ask this one quick question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to just
Thank
go do that
Thank you.
and not have to come back here.
Yeah.
And I'm trying to consolidate this now so you can leave in half a day today, rather than coming back. I'm just trying to make the best use of it.
Oh yeah, she's trying to do the best of it
Your Honor,
now
11
now that there's a federal appeal going on.
By the time we get done, that's fine.
All right, so where do we stand in the motion for reconsideration? Sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that, obviously. We gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they had received that. There is still metadata, we believe, on the Canon PD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert put in his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need? I know this motion is just filed. How long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
I think we'll file.
All right, I guess I'll find a court case or some court cases to watch tomorrow.
If we have motions, maybe Friday. So I
Yes.
think I'll make a motion in writing, but I think we will to have the weekend the court allow, because with all of these hearings taken away quite a bit of our time.
Right. Can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday and I don't need to bring everybody back on Monday.
We can do that.
Your Honor, I would ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions and when we do on Friday. I know the court would like us to have, the brief as the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss though, right? You've had this since, so you've got these recent ones, but I need to know how that, are you going to argue that in the motion to dismiss?
Well, I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be
See, you always try to rush the defense, but you're telling the Commonwealth, "Oh, take as much time as you can." I mean, the DNA on the dog, on the wounds of the arm, the dog DNA bullshit that you waited almost till you started the case. It's ridiculous, but you get all the time in the world, Commonwealth. So biased.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising to the motion to dismiss, and then I'll run a supplemental very quickly thereafter. I have to decide this and put something right. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
Yeah, 1 minute.
I can't believe they're done for the day. Well, I mean, you should have filled the day full of motions today, Judge. This is your fault. You should have filled what you could up.
Your Honor, given what Mr. Lee just said and the court's concerns, I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever. Could I ask the court if it's okay with Mr. Brennan, we can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings. Let's just argue this tomorrow. I will concede the motion to dismiss. I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to wait. I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow if that's okay with the court.
Are you waiving the additional argument that Ms. Little says? Are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation is true, and I don't think that we need to file a supplement, which is really where the hang-up is. I don't think we need to. If the videos are the videos, we don't need another supplement.
All right. Ms. Little doesn't.
I wouldn't believe you Mr. Lally one bit.
Right. Her key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay, what's the Commonwealth's position?
I'll defer to the court. I know it's more complications with the defense and travel will be available when
So I think we did log off today and tomorrow.
Yeah,
with the
you did.
Understanding that the defense team would not be here until sometime 11 o'clock or later. What about Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be on Friday.
If you're going to be here on Friday.
I just won't be here on Friday. So if we do the motion to dismiss tomorrow, I can head back tomorrow evening. Ms. Lee will handle her motion anyway.
I greatly want to accommodate the defense as we have the entire time I've been here.
Oh, now you want to accommodate the defense.
More court hearing days. We
When you weren't accommodating before, jerkface, you want him off the case. Oh goodness, this is the longest hour.
All right, so Ms. Little already filed the motion for me to reconsider. Why don't we hear that tomorrow as well?
Very well.
Okay, and then we'll just finish up everything tomorrow.
Very well.
All right. All right, and then you won't have to be here Friday, but the motions in limine are all filed. It also involves filling out a final trial conference report. So you need to do that as well. That all has to be done by Friday.
Understood.
And then, my goal was not to bring you back one day at all next week, because then we're gonna have a full hearing. I believe it's the 18th, the motions in limine.
That's right, the 18th.
All right, so we have a whole week next week to, you and I both, try and get everything done.
Should we file a formal motion to ask the court's permission for delay from Friday till Monday?
For the
Motions in limine.
Commonwealths were due on, the defense were due on Thursday, Commonwealths on Friday. Were they all on Friday?
Reciprocal discovery is due Thursday. We want that to happen. Motions in limine, I believe, are due Friday.
Ms. Little, would you like the weekend for all those motions in limine?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you
All
very
right,
much.
motions in limine to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the dollar motion for Dr. Wolf. It has not been heard yet.
A Daubert motion for?
Dr. Wolf is a neurologist. So there's
Oh,
one
I
additional.
was thinking the archivist.
No, Your Honor, it's the neurologist for the Commonwealth. Wolf without an E, WOLF. That was filed 2 weeks ago, I believe.
I have not seen that.
Okay. I'll make sure that the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a Wolf as well, and I received their amending motion, and we'll be prepared anytime to argue that.
Do you want to argue it tomorrow?
I'm comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow. All right.
Well, you should have did some today, lady.
Leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just contact the clerk's office.
Sure. Okay.
Anything else for today then?
Not for the defense, Your Honor.
She sure hates working a full week work day, doesn't she?
So I'm going to give you all a, why don't you fill out all the signs on the application?
What's going on, Ryan, please?
All right, well, that's the end of today. They'll be back tomorrow to do their motion to dismiss. Hey, Amanda, they'll be doing their motion to dismiss on the defense or the whatever. Anyways, so I will be back tomorrow to finish it up. I appreciate everyone that came through and hit the like button, shared it out, all that great stuff. Your support means the world to me. Let those that you love and care about know that you love and care about them, because tomorrow is not promised. And everybody have a blessed day.
Turn me up, AV.
Put your eyes on me, yeah. Like the spotlight. Recognize me showing love, then got my grind right. Ain't never since day one to love it on side. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you, dog, just what it gon' be. Definition of bestie, definition of friendship, definition of rider, definition relentless. She's a strong woman, she's a sweet lady, she's a great mother, let your pain get achy. Yeah, I made that girl on YouTube, she never dims my light or put me in her dark mood. And I thank you, you appreciate it. You're my favorite girl on YouTube, and I can't fake it. You still got faith in me, make me feel like big. DJ Khaled voice, pretty hot then. Who still got faith in me, make me feel like big. DJ Khaled voice, pretty hot then. Yeah. Met a little shawty on this show called BDP, you know what I'm talking about? Shit. We been cool ever since, my nigga, you know what I'm talking about? Put your eyes on me, like the spotlight. Recognize me showing love, done got my grind right. Ain't never since day one the love been on side. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you, dog, just what it